Avenue.
Meeting is being recorded.
Oh, yes, and the meeting is being recorded. I'm sorry, I should have said that. Um, and and really it involves a lot, whether it's a lot as a corner lot, abutting more than one street, and the required setbacks for construction and relocation of accessory buildings. The Hears are appealing the determination of the Dover building inspector that the lot is a corner lot and is accordingly subject to setback requirements for a corner lot. What we're going to do today, we are going to allow first the attorneys for the applicant and also two of the neighbors who have filed appearances and filed very thorough briefing with us. We're going to allow them to speak. We'll open this up for board questions. We will then ask for citizens to comment. And again, I'm hoping that all of us, whether it's attorneys or citizens, we try not to just repeat too much what has been said before. Feelings are very strong on this. But after those comments are completed, I'm then going to close the hearing for purposes of accepting any further comment or any further information. The board is then going to deliberate. It's going to come to a decision one way or the other on this application. And then, because it's fairly complicated, I would be asking the board to then vote to schedule a separate session in the near future where it could then review a written decision that I would draft, have our council review, and we would meet briefly at that point to comment on that draft decision. I would circulate it ahead of time. But we can't really do this with comments over email because of open meeting law. So we will need an additional, and it'll be a very brief session. Just to review that, I would then sign the decision, and at that point, we would, file notice of appeal. Now I see here, our screen is set up where Mike is, for some reason, at least in my case, Mike, or Chris, let me ask you, why is Mike Donovan's picture? I love Mike, but he doesn't want to be the star of the show. Neither do I. Is there a way to address this so that the audience could be looking more at the person who's speaking?
Yeah, I think I just fixed it. What happened was your view might be on speaker view, which makes
Oh,
whoever is speaking looks like there's some interference coming from Mike's side of things. So that's probably why he's popping up a bunch. But I
okay.
just changed the attendee view to gallery, so they should see everybody all at once now.
Super. And I think, yeah, if people who aren't speaking, if you keep your microphone off, that will prevent that.
Yep.
I still miss the days when we could all sit in a room in town hall, but those days are long gone. Okay, I think the first person I would like to hear from is the attorney for the Hears, Vincent O'Brien, whose hand is raised. And let's see here. Chris, would you admit Vinny so he can speak?
Am I there?
Okay.
Hi, everybody.
Hey, hi, I'm Vinny. Yeah, speak up. I'm having just a little.
Sorry.
Yep, that's better. Yep, go ahead. Whoa.
He's muted.
Yeah,
Yeah, he's muted.
Yeah,
There you go.
How about now? Okay.
Hey, okay.
Technology, George, is not our friend. We've met on this several times, and I don't want to overstate things, but three simple things. One, this is not a street that was ever approved by the planning board, either as a pre-existing way or a subdivision. So under the rules and regulations of town of Dover, it's not a street. physically and factually, you can't drive on it. It's not a street. And legally, it was never accepted by the town properly. And I think I provided the board with what I thought was a pretty good memorandum on point, which specifically requires 3 steps to be taken for it to be properly taken: layout and acceptance, which were done, and then acquisition, which is an absolute necessary element of the taking. So from my perspective, it's not a street, it's a parcel of land. And as such, the sideline setback doesn't apply as a street. And I'll leave it at that. I think I've given you more than enough information, and you've heard from me too many times. I think I've made my late case, and I'll defer to the board. Thank you.
A modest and soft-spoken attorney. Thank you. That's great, Benny. I think is John Doherty here? John had spoken earlier and has submitted two memoranda. Okay, if he's in that's fine.
How's that?
Oh, there you are,
Good.
John. Hey, and John, before you get started, I do
Yeah.
want to inform the meeting. You all know, you attorneys, that true to our word, Chris Costello set up a link on the Board of Appeals webpage in the town website, and we have actually put on that everything that we have received and that is relevant for this matter. That's open to the public if you did want to see that. And I know there had been curiosity from a number of the neighbors, but that has been done. And thank you, Chris. John, proceed.
Thank you, George, and thank you, Chris, and good evening, everybody. So I'll also try to be quick here, and thank you, Vinny, for that. So I think Vinny is attacking this from whether the extension is a public way, but we're trying to determine whether the extension is a street as it's defined under the bylaw, so it can be a public way or a private way. And what we're grappling with is, what do we do with this town meeting vote? And I think Vinny's suggesting it should be disregarded or nullified because no deed was recorded. But we know that the statute and the vote use the words "if necessary" and "as may be necessary" with respect to acquiring the land. There's no deed or easement recorded for many streets in town. And that Kopelman and Page memo that Vinny had provided did have reference that some municipalities choose not to record deeds or easements. But in fairness, in the spirit of transparency, Kopelman and Page is not necessarily recommending that, but they acknowledge that without a recording, the acceptance at the town meeting creates a license for the public to use the accepted way. So we're not throwing out the town meeting vote, throwing it out with the baby out with the bathwater on that. And to that point, the board does not have the authority to nullify or modify the town meeting vote, and that can only happen at town meeting. So that speaks to the public, whether this is a public way. But the other part, so you don't buy any of that. If you don't like that or you're struggling with it, the other approach here is that it's a private way. So it's still a street under the terms of the bylaw. And as we heard last week, a number of neighbors had mentioned that for years, many years, they've used the extension to access the church. They used it for walking the trails. And in fact, the Gertler driveway is actually located, the curb cut or the opening to their driveway is in the extension area. So in conclusion, I'd say that it's either a public way or a private way, but it sure is a street under the terms of the bylaw. So I thank the board.
Thank you, John. Ben, are you here? Here he is, Ben Dowling. Chris, would you admit him, please? And Ben is the attorney for the Gertners who live across the way. Ben, if we could get you here instead of John, that would be great.
Can you hear me?
Yes, we've got you, Ben.
Great. I don't have a video right now, but that's okay as long as you can hear me.
We're relieved, Ben. Thank you. Go ahead.
Yeah, so I am going to be brief as well. I'm going to echo what John just mentioned, which is that the bylaw, it doesn't require the road to be either public or private. And so that the Koppelman memo really is irrelevant to this matter. And um and and furthermore, the unimproved portion of Oakley Road, it meets the plain dictionary or it meets the bylaw definition of what a street is. And the bylaw definition of what a street is includes a way and it includes an alley. And so the unimproved portion of Oakley Road is clearly falling within that definition. And it's open to public use. You heard testimony from neighbors and residents that they walk in that portion of Oakley Road, in the alley, if you will, in the path that exists there. And so for that simple reason, the lot on Park Avenue very clearly falls squarely within 185-23, which is to say that it abuts more than one street. So I think that the board, it must uphold the building inspector's determination here. And I also I want to echo as well that the board should be very careful to not to overturn the town meeting vote to accept Oakley Road as a street, as a public way, that is. And it would be just a an anti-democratic action on part of the board. And so for those reasons, the building inspector's determination must be upheld. Hopefully you can still hear me.
Thank you, Ben.
Good.
Board members, do you have questions? And I think the question should be addressed now to Attorney Vinnie O'Brien. And do you have questions about that he might answer? And I ask, when you have questions, state them, and then you're coming through me, the chairman, so that we not have too much of a direct back and forth. Does anyone have questions that Attorney O'Brien should answer? And the only question I have, and it really actually deals with the last point. I'm not sure if it was Ben or John who made this point about the driveway. Could you give us a little more information about the driveway and the curb cut that does seem to go into that Oakley stub? There seemed to be a feeling at our last meeting from Tom here that was not the case, if I understood it correctly. But looking at it and actually looking at pictures that Tom submitted with his application, and also speaking with the building inspector, it does seem that at least a portion of that driveway cuts into the stub of Oakley. So I'd like to know, Vinnie, what is your position on that? Is that do you dispute that fact?
Now, his driveway does get from the main street to his house. I'm not sure how much of it is on his property under the derelict fee statute, and if any of it's on Tom's, I don't know. I haven't engineered it, but that's a driveway. The driveway is not a street. If you look at
it's what is it accessing?
his property.
So, and that's because your position, I believe, is that because the town does not itself have title, not having perfected title after the meeting, that the piece of property, which is owned half by his lots and half by the Here's lots under a peculiar type of ownership. It's not something they can alienate or block off, but it seems to me just something that the legislature at one point or another decided someone has to own it if the town or the developer does not. But he's accessing that property, the Oakley stub, whether it's a street or something else. That is being used as access for his driveway, correct?
It's being used as a driveway. Yeah. It's
Okay,
similar to, if you look at, there's two 40Bs in the center of town. One
yeah,
is Dover Meadows, and the other is Dover Farms. Dover Meadows is a driveway. It's not a road and never will be. So you can have a driveway, but having a driveway over the front or crossing across the front of a piece of property doesn't make the rest of that property a way. It doesn't meet the definition of a way. It's never going to be approved by the planning board as a way. It doesn't have sufficient width grade of construction. It was never on a subdivision plan that was approved. It's land court property, so you can't gain an easement by prescription. For so many reasons, it's just not a street. And I think the Copeland Page memo is clear that it's mandatory that the town acquire ownership of it, and they never did. Now, Tom has the right to use his property, and the Gertlers have the right to use their property. They have access to it. I think the town should ultimately address the issue of the entire way for the neighbors. But for our purposes, it's not a street.
okay.
Sorry,
Vinny, what I would like,
George,
Idea.
I'm sorry, Nadia, go ahead, because
can I just pick up on that
You
thought
bet.
you just shared? So Vinny, if I'm sort of understanding where George is saying, right, which is that at least part of the Gertler's driveway sort of accesses or sort of, is sort of from that sort of stub. And if I'm understanding you correctly, that basically both property owners will sort of own all the way to the middle of that stub line. Could, the Heers put up a fence directly all the way through that stub from edge to edge and then block part of the Gertler's driveway?
In theory, yes, but no, they're not going to do that.
I'm not sorry, not saying that they would. I'm just trying to, so under your sort of,
And again, I think George said it properly. And the derelict fee statute is, the name almost defines itself. It's the fee that's derelict, who owns it. So what has typically been done, every case I see, there is ownership to the center of the way.
Sure.
But they consider setbacks from the existing lot line, not from the center line of the way. But this way, at least they know who owns it. So I haven't seen a dispute about a fence in the middle of the way. But for sideline setbacks, which we're discussing, the sideline of the actual lot has always been used. My contention is that that property is owned by somebody. It's either owned by the original developer because they never conveyed the fee in the way, or it's owned under the derelict fee statute. Interestingly enough, there's an existing case pending. I'm not sure if it's gone up to the Supreme Judicial Court, but the land court had a case where they found that the derelict fee statute did not apply to a land court property, but the appeals court overruled them and said it did. So that it's still a bit of an open question, but either this property belongs to the two landowners, or actually still owned by the original guy who did the subdivision, because you cannot acquire ownership to land in land court by adverse possession. But you can, according to current law under the appeals court case, it was a beach case, can't think of the name of it. You can, the derelict fee statute does apply, which does allow ultimately the town to acquire these lots by everyone on the street conveying their interest to the town of their half interest in the street all the way down, which should be done ultimately, irrespective of what happens with this decision. That should be cleaned up and done properly at a not future date. But it doesn't, accessing it, cutting through it, walking through it doesn't make it a street. It's not a street. It's not a physical street. It's not an approved street. It's not a public way. It's a piece of dirt.
Can I speak to that?
John, actually, I'd like to pursue this a bit further, and then you'll be able to. And I want to share my screen because it concerns me. It seems that we're using a very narrow definition of street, which is not the definition in our bylaw. And I want to first share with you what the actual definition is. And bear with me. There, right there. Okay, a street. I mean, it's a lot more than a way. It's a public or private way, an alley, a lane, a court, or a sidewalk, which is open or dedicated to public use. That is 185-5.
Mhm.
And now, and then our bylaws say, if you need more clarification, for some reason, they use the Webster's 11th edition, which is the collegiate edition, the one all of us had in college. And I think mine was maybe the 3rd edition, but but that's important because, we're not talking about street frontage. That's a much more rigorous definition. You need frontage the way it's also defined, and I'll go to that definition in a minute. You need frontage if you want to have basically a buildable lot. If you're going for an A&R, you need street frontage, and we've got a separate definition for that. But the definition of street is an awful lot broader.
Well, the problem with that,
And let me just
sorry.
continue for the benefit of the board, because I spent $7 and I got this through eBay, Merriam-Webster's definition. You've got alleys, lanes, and my goodness, even a lane is a relatively narrow way or track. A track is a path, repeated footfalls, a trail. Now, again, these are not things you drive a car on or a fire truck, but they definitely fall within the town's definition of street. And so that's the first thing that caught my eye on all this. The other thing is, whoops, let me just see here. Here is our street frontage interpretation. You can see it's a lot narrower. And I think we could certainly determine, at least at this stage of its existence, Oakley, other than maybe the part where the driveway enters, but of the Gertners, but there is no street frontage. So you couldn't go to a planning board and say, I've got rights to an A&R, an approval not required lot, because there's no street frontage. However, our corner lot definition does not say a lot abutting on more than one street with street frontage. It just says abutting on more than one street. And if that's the case, then for each street, you treat that as if it were frontage for purposes of setback, meaning you go back, in an R zone, you go back 20 feet on each side. So, and Vinny, this really gets into the very good case you cited, which deals with paper streets. And the way I read that case, a paper street is a street basically without street frontage. It's just something that is on a plan, but it hasn't been developed. So for that purpose, it's a paper street. And the case you cited, which I think is it's actually more on point to determining the issue. And let me just get to that for a minute. Yeah, Shea versus Board of Appeals. And this was basically a case where the question was, because it's a paper street, did a person have a right to have a lot on it? And what the Board of Appeals said basically is that there is no right to have a lot, an A&R lot, on a paper street. No question about that. But that is dealing just with essentially, do you have frontage? And a paper street, you don't have frontage. You don't have frontage under our bylaw, and you don't have frontage here. But, you know, what the court went on to say was that it's not suitable for vehicular traffic. You can't drive a fire truck on it. But let me just see here. You know, a zoning bylaw that requires frontage on a way must be understood, if the purpose is not to be undermined, to require an actual way. That is for frontage, not just a depiction of a way. Now, the planning board in this case had actually approved it, and that's why what the fight was about. And they say that approval may have legal significance under the definition of street if it's depicted on an approved plan and if it has been constructed as approved. And it doesn't just mean it has to have been constructed. Under Dover bylaws, as I understand them from our council, we don't have something in our bylaw that requires that the road be in existence to be a street. That in fact, we apparently again have this very, very loose definition. It is something that possibly could be constructed. I did a little searching with the land records and our council and also the assessor's office. And another thing that is really a new fact for us is that when you go from the end of Oakley Road to the church parking lot, that there is a 40-foot right-of-way that goes basically from the boundary of Oakley all the way to Center Street. And that, I think, may have been done in connection with some development that the Catholic Church did back in the 1950s on the property. But that's also a fact that indicates that this is not just something on a map. It seems to fit within this very broad definition of street. Admittedly, it has no frontage or very little frontage by the driveway, but the shared, the corner lot definition seems to be requiring only that it be a street, and that definition again is extremely wide. A private way, public way, alley, lane, court, side or sidewalk, open or dedicated to public use. That is actually what our law is. So I mean, Vinny, I've thrown a lot at you, and you're probably saying, "Oy vey."
No.
But those are things, including the facts of the right of way and the driveway, and this very broad definition, and admitting there is no frontage. How do you say this is not a street?
So two things. I totally disagree that you can separate street from frontage, but put that aside for a second.
Yeah.
By your definition, you're saying that all the cart paths in town are streets.
All the what?
Cart paths in town. There's hundreds of cart paths in town.
They
The streets.
they don't have frontage.
No, I know. So, but using your definition of a street, you're saying it could be a path, a cart, a lane.
Well,
not
that's
a
the
street.
definition in the bylaw, Vinny.
Right. So what you're saying is that all of the people who have a cart path on their property, their setback has to be as a street from a cart path. That makes no sense. Common sense.
Yeah. Oh, listen.
It just doesn't. Wait.
I think if any of us, and I believe at some point we may actually be looking at all of our zoning bylaw and trying to change certain things. And I think we could, as a matter of common sense, a sidewalk doesn't sound like a street, but when you get to this broad definition, it involves, it's not just limited to cars. It involves
Right, so
foot
I
traffic,
think,
other things as streets.
so yours,
But they
but
don't
that-
have frontage under this definition. And so, that definition. So as such, you can't build on them. You can't build on them. I mean, build off of them and use them as streets for that purpose.
I don't think you can separate frontage from street, but. be that
Well,
as it may,
but I think you
if
can, Vinny,
you say-
because now what
Sure.
this does, we've got lots that are all on a subdivision plan that's approved. It's in land court. People own their lots. And
It's not an
to
approved
say
subdivision plan.
that because you can't drive on the street means that all of the zoning restrictions for side lot yard, everything goes in the pooper.
George,
And that doesn't make sense to me.
it's not an approved
Yeah.
subdivision plan. It's not an approved subdivision plan. It's
Well,
just,
no, I didn't say it was approved. It's recorded. It's recorded in the land
It
court.
is recorded.
And it was
There's-
done back in the 1920s before we had a.
and there are probably 20 or 30 of those in town that have paper streets that have never been developed and never will be.
Yeah,
But if you're saying that if it meets your definition of street and you will somehow bifurcate frontage from street, then you're saying every path, every cart, every sidewalk requires everyone in town to have a setback to meet those stringent requirements? That doesn't make common sense. Either
No.
it's a street, a cart path is not a street, a sidewalk is not a street.
well,
That's just how I feel. I just don't, I don't understand how you can say that's a
Yeah.
street. It doesn't look like a street, doesn't
Okay.
have a street, and it was never accepted as a street, never
Yeah.
approved by the planning board as a street.
what
None of
and
the
what I'm thinking, Vinny, but again, and this is before the board will get into deliberation. So board members, I think, we will, but it's fair to Vinny to be, speaking, to this point.
All I can see is what's on your screen. I'm not seeing the full screen. But do you have the map, the original 1926 subdivision map someplace on your
Yeah,
scroll there?
I
Because if
can
we
get
looked at that once more, that might answer my questions, because I look upon this as, there's two roads. One goes straight and the other one goes off to the right and curves around the corner. So obviously, Mr. Herr lives on a corner lot. Whether or not they finished the street, we don't know why they didn't finish the street. They got down to the end. Now, maybe the town wouldn't let them finish it because they'd have to make a cul-de-sac or a dead end, or maybe they didn't want to go through to Center Street, because don't forget, where the Catholic Church is was just a bunch of woods. That wasn't built until the 60s, and this is 1926. So we
Yeah.
don't know why, but just looking at the map right there, it's a corner lot. I don't know, you can go back and forth, the carts and paths and walkways and whatever. It's not gonna change it.
So that means that every single paper street in town now.
I'm not talking about paper street, I'm talking about the street that's right there, I'm looking at it.
But that's a
Yeah.
paper street. It
And
doesn't exist.
Vinny,
on land.
but we're not, one thing, I mean, listen, we're quasi judicial, I guess. And,
Right.
we're not legislative. And, I think it's always best when you're deciding a case, base it on the case in front of you.
Yeah,
We are not, I don't know the facts of I mean, you certainly know the geography of town better than any of us. But, I think here as Laverne says, focusing on this
just look at
particular
it.
plan, it sure looks like a street. It's being used. We've got this broad definition of street that covers, even says a sidewalk's a street. There's no question at this stage that is not, there's not street frontage there for purposes of A&R approval or other stuff. I mean, but it is a street. Just like the rest of Oakley is a street, regardless of whether owners have signed off ownership rights as such. It's a street on a plan. People bought into it. Otherwise, I mean, it's pretty hard under your theory to say why would there be any restrictions, say, for lot 17? Is that sure looks like a corner lot to us, but it's not a corner lot?
So here's the
I
problem,
know.
George. You're saying the fact that it's drawn on the plan means it's a lot. Okay. That is why eventually the legislature created the subdivision control law, because exactly what you're talking about happening got
Yeah.
out of control. People were drawing plans on paper, selling lots and taking off. So they created the subdivision control law so that the roads would be constructed in a proper and organized manner. And the planning board has the right to approve a subdivision, or they can accept a way in existence at the time of the subdivision control law of suitable width, grade, and construction, and provide that as a way. This is a piece of dirt with a driveway cutting across the front of it. It's not a street. It's not a public way. It's not a private way. You can't access it. And to say that because it's a people cut through it and cut through to the back, that it's a path makes it a street, then every car path in town is a street based upon that definition.
Well, let's again, but the fact that people who are visiting the owners of lot 7 and 8 on the plan, I mean, it's now the Gertners,
Mhm.
they're on Oakley Road, accessing a house on Oakley Road on a driveway that is on this, was apparently built. The paving was extended, and that certainly that portion of it. If any little portion of that is a street, simply public's using it, it's on driveway, it's paved. Um, you know, even then, the heaters have a corner lot. It doesn't say that the entire side boundary needs to be a street with frontage or at all. It's being used as a street and also certainly for walking. And who knows what the future is? You know, when you look at a map, the part that's not shown here is the church property. That big parking lot goes on to Center Street. We've got the school. Who knows what the future of Dover is? And if at some point maybe there could be some transaction, who knows? But you know, I cannot see on these facts saying that this is not a street, that therefore either lot abutting it, whether it's the Gertners or the Heers, can now build accessory structures up to 7.5 feet from the boundary rather than 20 feet. I think that really precludes the usefulness as a practical matter, right? And since we don't have to have our streets, according to Nina, and Nina, again, you're going to help us with this decision.
George,
Uh,
George, can I ask a question? I think if you
Sure,
scroll
Nadia.
to the next page of this attachment, I think there's a diagram that reflects the
Yes.
driveway, right?
Good
So
for you.
if you know, and Vinny, if you can help me figure out how do you distinguish kind of the portion of that Oakley Road kind of stub that is in front of the driveway that presumably has been, you know, sort of improved upon, right? That there is that sort of,
Yes.
you know, kind of paved portion from sort of the rest of it that you're saying sort of isn't a street, isn't kind of been adopted. And so, you know, I guess, do you distinguish between those two, or again, you know, I keep coming back to, it feels like if there's a part of it that has been kind of improved and is now sort of part of what is effectively that the balance of the
Yeah.
Oakley Road.
I, you know, I'd be inclined not to think that the test is how far is it paved.
Sure.
But if it were the test, it looks at least that part of it is paved. Now, if you bear with me, I'm going to stop. Let me just see if I can find this. Tom actually submitted photographs with a memorandum that I think might make this more clear. Hang on. Yes, right here. Are you able to see that on the left? Are you able to see that photo?
Yep, I
Okay,
can, yeah.
and yeah, I mean, this is, Tom here submitted this. And you can see Park Avenue, Oakley, it does go in a bit. Certainly it's not paved all the way to the church parking lot by any means. But that is a fact, and I know that was something, because I spoke with the building inspector, and he didn't, again, I don't think we need to rely on this for purposes of the decision, but it is certainly a fact that shows it is not all dirt. Some of it is paved and done for purposes of getting access to a house that's on the development plan. Okay, let's see here. I think if there are no other board questions, then we're going to deliberate ourselves, and we're going to do that in public. But I think here, what we ought to do, I'm going to stop sharing here. We can allow for some neighbors to speak, but I'm going to really, again, please don't just bring up again stuff you've talked about in the past. I see Heidi Handler has raised her hand, so let's have her. Let me see if I
I
don't-
think I'm unmuted. Can you hear
There
me
we
now?
are. Okay, Heidi, you're on.
Yeah, just my question, and it's picking up on Nadir Ahmed's question in that I believe the last time I asked, I had some questions about the planning board, and you had said that the time to appeal that had passed. I'm not aware that I had standing to appeal that. I was never sent a letter or anything. My question with regard to the zoning board of appeals is, I also asked the last time, what happens if this is approved? Doesn't this have to go back to town meeting? And you said, nope, that's the end of it. It doesn't go back to town meeting. I have some real concerns about that related to, does that mean that the Hears could build right away? My property actually does border on Oakley Road. I'm 15 and 16, so I'm all the way through
Okay.
to Park. Does that mean that I immediately can build a fence in the middle of Oakley Road down?
No.
Well, but why
Well,
not?
there is no right to build a fence. And again, there can be a million related questions to this issue. And getting back down to a lot of the discomfort about the noise, the alleged noise, whether there's a business, we aren't doing that.
No, my question
Yeah.
had to do with the effect of your decision, is that I'm
Well,
not intending to build the fence.
The effect of our decision is, under the law, once we record this, there is a 20-day right to go to court. That's where your appeal is.
The 20-day right to go to court, okay? And
That's
so it
correct.
does not go back to town meeting at all,
No,
even if
no,
you're
no, no.
overturning a
It-
town meeting decision?
And
That
at
was my
that point,
question.
yes, and at that point, yeah, an appeal, you can have all sorts of things in the appeal. If we do decide that this is that if we decide to overturn the building inspector's denial.
Okay,
Okay, but
that was my question, because you had said that there was no right of appeal. So thank you for clarifying that.
okay, you bet. Is there anyone else? And if not, I would like to have a motion. Oh, let's see, I don't think there's anyone else. May I have a motion from the board that we terminate the hearing as such, in order that we be able to then enter into a session to deliberate, and then to render a written decision from which any party may appeal to court within 20 days. May I have a motion, please?
Mr. Chair, if I may, real quick, it looked like you had one more raised hand.
Oh, okay.
It's down now, but I'm seeing Yep, there we go.
Who? Well, okay, Chris, if you can, yeah,
Yeah.
Mike,
I'm trying.
sure.
So, Indra and John, did you have a comment to make?
Yes, I just wanted to make a comment about your favorite case, the Shea versus Board of Appeals in Lexington, which seems to be so. If you read further down in that, it says the Superior Court affirmed that the town officials were correct in withholding a building permit for the plaintiff's lot, so long as the section of Rockville Avenue on which it fronts remains unconstructed. So they're saying
That's
it
right.
could be constructed, and that's exactly what we're saying out here, is no, we don't have a street frontage as long as it remains unconstructed, but the right to construct it remains in the Shea case, and we say should remain with us.
You're correct. I read it the same way.
George, could I just
thank you.
comment on that real quickly? The
Yeah.
the difference between the Shea case and our case is the planning board approved that plan. This plan was never approved. It doesn't meet any of the current requirements of the planning board.
Yeah,
27 years.
Put it with grade and construction. It would never be built. That's all.
yeah. The planning board approved, and and then that essentially lost the case. Okay, let's see here. I think, may I have a motion to, hang on just a sec. I've actually got some formal language here. Hang on just a minute.
George, may I ask a
Yes.
question,
Sure.
Vin, before we close? If this was approved in town meeting back in 1998, would we have had this discussion today?
If,
It feels like it was approved, but it was never followed up. The instructions were never followed up.
that's a good question. If
You know, that's a question for Vinny, because it still hasn't been turned into something you could drive on.
I would
Vinny,
still be
what
arguing
would
it's not
be the case then?
I would still argue it's not a street, but
Yeah,
they
you
did
would.
it correctly. It's interesting. About, I don't know, about 6 or 7 years ago, the town accepted maybe 5 or 6 different streets properly because they had never been accepted. But Nancy, if it had been properly acquired and accepted,
We wouldn't have this hearing.
But I don't know, it would still be a corner lot, no matter when you
Yes.
looked at it, it's still a corner lot.
No. If the town accepted it, then it
Yeah,
then
as
it's
a,
clearly
as,
street, or more clearly, it's a street. Here, in this instance, the town never did it properly.
Wouldn't you be
But they
arguing?
did,
though,
they
that-
did, they
I
did,
was-
they did vote for it, Vinny.
Right,
They
but they
accepted
didn't-
it, but
they
they
didn't
never
acquire it
recorded.
properly.
Yeah. So I feel like in the spirit of town meeting, everyone said yes. But then there was someone dropped the ball.
Drop the ball. Yep.
Okay. But yeah, thank you. Thank you, George.
Okay, and just bear with me a minute.
And what would have had to happen, Nancy, just so you know, either the town would have to take the land, or all the landowners would have to deed it to the town. That didn't happen. And each of the landowners would have a say in that, including the Gertners and Tom.
George, the motion to close the hearing is just that, so it can be quite
Okay.
simple.
Very good. May I have a motion to close the hearing?
I make a motion to close the hearing.
Second.
All in favor, and a roll call vote, please.
Mike
Nadir
Donovan,
Ahmed. Go ahead, Mike.
Laverne Lovell.
Nancy
George.
Green,
Yeah.
associate, yes.
And George Chimento. Okay, that's it. And now we can start to deliberate in public. I know I've seen some boards sometimes go into executive session, but there's no reason to do that to my mind, and it's good to have this be an open process, just as we have had up to now. Board members, you've heard my theory, which is that we have a very broad definition of street. It goes way beyond a narrow definition of something that is paved. But my belief is that with that broad definition and the fact that the corner lot is defined as a lot with essentially with two streets on its boundary, to me, it is not relevant whether it is something you can drive a fire truck on. It's on a plan that's recorded in land court. Everyone has bought into this. There is no frontage. You couldn't build a house just relying on there being dirt and trees in your front yard. But in other respects, my belief is that the setback rules make sense. That if you're going to build an accessory building on a corner lot, and in our zone, you've got to be 20 feet from the street boundary. And that's measured from the street, not from the midpoint. But is there anyone who feels that this is not a street and that the accessory buildings should be permitted, as the here's request, to be as close as 7.5 feet to the Oakley boundary? Is there anyone who feels that way? And we can explore that further.
Yeah, George,
Yes, Mike.
I've been thinking about this for a little bit, and to me it comes down to, I think Vin is looking for a finding, I believe. Is that correct?
I'm having a little trouble hearing you, Mike, with your microphone.
Hold on, let me I believe Vin O'Brien is looking for a finding.
He's saying a finding. He's saying Vin is looking for a finding. Is that correct?
Well, I believe, Mike, I think what we're going to do, what I'm going to ask for after we get a decision one way or the other, is for a vote, which then moves us into a separate session. We would continue this. That I would, with Nina, we would prepare a decision and circulate it by email, and then we would get together and edit it to the extent necessary, and then finalize, and then we would have a decision, record it, and that would then start the 20-day appeal period.
Okay.
Okay, but yeah, I think here, let's see what things we agree on. Is it your sense that Oakley, even the undeveloped portion, is it your sense, or actually your decision, that it's a street and that this is a corner lot? That's really what we're thinking about.
Well, to be a street, should have been accepted by the town in the 120-day period.
Well, that's to be a street owned by the town. But again, our definition, Mike, in the bylaw does not require town ownership. And let me,
I got you.
yeah. I mean, it's basically what it says, and it's short and sweet, that a street is a public or private way, alley, lane, court, or sidewalk, which is open or dedicated to public use. You know, in a way, this makes sense in a way, because even with a sidewalk, you know, if you're thinking about setback rules, yeah, it makes sense. Uh, this is not saying that you can drive a fire truck on it. That's where you need to get to the definition of street frontage. And that narrows down this definition of street to something that makes a lot of common sense. But this broad street definition actually does make sense if you were thinking, okay, when that's near on a boundary, you know, isn't that sufficient? Isn't that sufficient to trigger the necessary setback requirements for the corner lots?
George, if I could jump in just for a second.
Absolutely.
So, Mike, you're entirely correct with respect to the 120 days to record in order to perfect it being a public way. But as George is saying, there's a difference between something being a public way and being a street under the definitions of the bylaw.
Thank you, Nina.
So I'll just offer my sense is that we, you know, operating with kind of the broader definition of street, that the fact that there is kind of a walkable path that connects kind of that Oakley to sort of the church behind, and I think somebody had said that Chickering, like there's an access to Chickering, that in many ways feels like it fits the definition of the broad definition of a street.
Yeah.
I think even in some of the pictures, and I want to say when we were walking, I understood that part of the path that we were on, that was sort of that footpath, was in that sort of, you know, stub area and not on, you know, either person's sort of property.
Thank you. Yes, I agree with that. Is there anyone else who would like to discuss further? Because if not, and let me just pull it up with the help of counsel. And Nina, I changed this just a little bit, but let me just see if I can find out where. Oh gosh, hang on a minute. Just bear with me, please. Okay. And Nina, before I ask the board to vote on this, you know, the draft vote, which I edited just a bit, would say the vote would be to reject the application dated January 24th, 2025 of Thomas and Christine here, to overturn the January 14th, 2025. In fact, let me share a screen here so you can see this. You know, if anyone had told me in law school that I would be doing this, that would be extraordinary. Let me just see here. Okay, are you able to see this?
Yes.
Yes.
Oh, yeah. So let's and board members, you look at this also.
George, this is fine. I have no problem.
Oh, excellent. Okay, and let me just get that little.
Yeah, be singular. Yep.
Okay, I know, Laverne, I knew you were on the edge of your seat. May I have a motion then? Because this will be, this is the first part. And then there will be a motion to allow the chair to draft a decision in accordance with this board's vote to deny the application to overturn the building inspector's decision, determination. Such written decision to be discussed at the board meeting on, and what we're going to have to do is have another day. I'd say give Nina and me a week to hopefully a week, maybe. Let me just see here. And we do have, I appreciate this. We have an extension until May 23rd, Friday, to actually have something filed with the town clerk. So let's look at calendars. I know, gosh, we've got other stuff coming on, but I think this really deserves a separate meeting. I think.
And George, if I could just clarify for a second for folks, I think what would happen at that second meeting is you all would discuss and make any revisions to the written
Correct.
decision that you would want. That's the kind of thing that can't happen over email outside of a meeting.
That's right.
So I don't expect that to be a long meeting, and there would not be any public comment or debate. You would just be finalizing that decision, agreeing to the final verbiage, and then signing the decision.
Thank you, Nina. That's exactly right. And everyone, we've got a hearing on the 27th for the Tisdale matter. Today is the 7th. If I would think I don't know with the Tisdale how much that's going to take. We as of today, I really don't know. Ideally, the peer review consultants will be speaking, and neighbors will be speaking. It's going to be a fairly long meeting. I mean, we could put this there, but I think it would be better if we picked a date like Tuesday the 20th, a week before.
Yeah,
this.
Yeah, you have to get this done by the 23rd, George.
Yeah.
Friday. So
Yes.
we have to do it like on the 20th or 21st. Yep, probably the 20th.
Okay. Is the 20th okay with everyone else?
All right for me.
Okay. Well,
All
then,
right for me. Yep.
excellent. Okay. Well, first,
Me as well.
let's go with the vote to deny the appeal. Okay, and may I have someone read this and move it, and then we can second and vote.
Sure. I move to vote to reject the application dated January 24th, 2025 of Thomas and Christine here to overturn the January 14th, 2025 decision of the building inspector, which denied the application of the Heres to build or relocate accessory structures on their lot within 20 feet of the Oakley Road sideline, and to confirm that the lot is a corner lot subject to the 20-foot setback required by bylaw, section 185-25.
Thank you.
23.
A second, please.
No, 23.
Yep. Second.
Thank you. All in favor, and we need a roll call vote.
Laverne Lovell, aye.
Nancy Green, aye. Associate.
Nadir Ahmed, aye. Member.
And Mike?
Mike, you're muted.
Okay. And George Chimento, aye. Okay.
I'm just going to interrupt you. I'm just going to interrupt you again. Who are the voting members for this application?
The voting members, we know Mike and Nancy are associate members.
Okay.
What we do in our minutes, we will show that they concur in the vote of the voting members who are Nadir, Laverne, and me.
Okay, perfect.
Oh,
But George, if we could, I don't know that Mike's vote was recorded audibly. I think he was still on mute.
Mike?
Yes,
Okay. Yeah, you voted, you would vote for this. I mean, and this is in case one of us gets, you know, for whatever reason, can't follow
Like
this.
dead.
Okay, yeah, no one, please. Okay. Okay, I next need a motion to allow the chair, and Nina, may I read this and make the motion, or do chairs not do that?
It is purely a matter that's up to the chair. So if you're comfortable doing that, you can do that.
Okay, yeah, that'd be easiest. This is, so I would move to allow the chair to draft the decision in accordance with this board's vote to deny the application to overturn the building inspector's determination. Such written decision to be discussed at the board meeting on Tuesday, May 20th at 7 p.m.
So moved.
Okay, and let's do the roll call vote again, please.
Do we need a second?
A
Second.
second. Okay.
Yeah, that was Laverne Level. Yeah.
Yeah, okay.
Nadir Ahmed, aye. Member.
Mike Donovan, aye.
Yeah.
Nancy Green, aye.
And
Laverne Lovell, aye, because I was seconding the
That's
motion
right.
before that.
well, everyone knows you. Who's
I
looking.
thought we were going to do that in alphabetical order.
That
We did.
was 2 meetings ago, Laverne.
I know we have to remember that though,
Never
because
stop.
we're all like,
Okay, and George Chimento, aye. Okay, so we are on, and I think then at this stage, the last thing to do is to have a motion to adjourn. Who would like to do that?
Make a motion to adjourn the meeting.
I second that.
Well, but don't we need to adopt the minutes from last meeting?
Oh, wait a minute. You know what? Gosh, good for you. Thank you. Yes.
Thank you, everybody. Thank you for taking the time.
Thanks.
Oh,
Jump off, George.
Thank you.
Nina, thank you, and good luck. You know, your boy's playing lacrosse tonight.
Yes.
Oh gosh, get
Thank
out.
you.
I'm in the car here. All right, take care.
Go be a
She's in the
lacrosse
car.
mom.
Bye.
Okay, thanks a lot, Nina. Okay, yes, boy, thank you, Nadir. Let's see, minutes. Okay, first we had a site walk, and these are all
I move to accept the minutes as drafted, as reflective of the
Okay.
meeting that occurred on March 26th.
Thank you.
Second.
All in favor, roll call vote.
Nadir
Mike
Ahmed,
Donovan,
aye.
Okay,
Laverne Lovell, aye.
Nancy Green, aye.
Mike.
aye.
Yep, and George Chimento, aye. Very good. Okay, that got that one. And then let's see here. Now, we've also got the April 30th minutes.
Yep.
And these were circulated earlier.
I make a motion to approve the April 30th minutes as written.
Yes.
Seconded.
Second, okay, and I know incidentally, Nancy Green ends with an E, and I will eventually get that through my thick noggin.
No
Okay.
worries, George. You got a lot in that brain.
Okay,
Boy,
thank you. And so did we have a second?
second.
Okay, and all in favor, roll call vote.
Mike Donovan, aye.
Laverne Lovell, aye.
Nadir Ahmed, aye.
Nancy Green, aye.
And George Chimento, aye. Now, okay, the next thing is we met in executive session to discuss a litigation matter. So we have got to, I think, in order for, well, actually, I circulated those.
Yeah.
We don't need to share the screen. All in favor?
How about this? I move to adopt the meeting minutes from the executive session on April 30th, 2025, as written and circulated to the board by the chairman of the board.
wonderful.
Excellent. I second that.
That's, well, you're right. You speak a great motion, Nadir.
Yeah, he does. He does.
Okay.
Nadir Ahmed, aye.
Nancy
Mike
Green,
Donovan, aye.
Mike, you weren't at the session. You can't vote.
Yeah.
No worries. Nancy Green, aye.
Yeah.
Laverne Lowell, I.
And George Chimetto, aye. Okay, yeah, and with these, I spoke with Felicia. She keeps executive session minutes separate and apart from everything else. Okay, now, Nadir, is it okay if we adjourn?
Seems like the plan.
Okay, may I have a
I
motion?
move to adjourn the meeting.
Thank you. Second,
Second,
all in favor, roll call vote?
Nancy Green, aye.
Mike Donovan, aye.
Nadir Ahmed, aye.
Laverne Lovell, I.
And George Chimetto, aye, and thank you, board members. Okay, I will get to work with Nina and get you a draft decision.
And you
And-
need it, you need
Thanks
to
so
get us
much.
you need to get us a Preakness winner. Okay, George, you need to pick a horse, right? You got 2 more races, buddy.
Oh, yeah, that's
No,
it.
oh my goodness.
2
Oh,
more
no, but-
races. Come on.
Hey, listen, I had a great horse. It took 15 horses to beat him.
Wow.
Yeah, but your niece is like royalty, so I'm very
I-
impressed
Oh,
with that,
yes.
right?
Yeah,
That was very impressive. Absolutely.
Oh, gosh. Okay, well, look,
So keep the ponies coming, buddy.
you got it. We will, and thank you, everyone.
Thank you.
All right.
Thanks so much.
Thank
Bye.
you. Good night.
Chris,
Nice seeing everybody. Have a good night.
Bye.
you
Thank you,
bet.
Chris.
Thanks for
Yeah.
shepherding us, Chris.
And now I
course,
know
anytime.
why I was never a lawyer. Too much talk.
Oh,
You know,
I know it. I
it's
know
a
it.
lot of, well, you have to listen to everybody and hear what they have to say.
You got it. I think, and hopefully, I hope this goes well with everyone. Yeah,
Yeah, it's
bet.
difficult. All right. Good night, George. Thank you.
Take care. Bye-bye.
Bye-bye.